So even though you were arrested for having sex with two kids that's 8 years old, then you don't even have to register. So you're gonna be moving in next door to somebody, and you don't even have to register. That's what I mentioned about the failure of the criminal justice system. And you're gonna go home, and you've got kids of your own, right?
Yes, sir. Yes, sir.
We are about to watch a case that will just befuddle the mind. It's probably one of the biggest miscarriages of justice that we have covered in the thousands of parole hearings that we have covered to date. And that is not a clickbait statement. I think you're just going to be absolutely floored when you watch this hearing unravel. It's insane. With that, let's jump in.
Your first class offender. The offense is cruelty to a juvenile, 2 counts. Sentencing date was 9/22/2020. And the sentencing was 10 years consecutively to each count. Parole date 12/23/2024. Good time date is 2/26/2026. Full time date 12/23/2039. Would you like to make a statement before we begin?
Yes, sir.
Go ahead.
I've been here. I took good time classes. I'm the head barber. I'm a trustee. I'm the head barber. I worked in the kitchen. I've been doing my best. I'm staying out of trouble up in here. I ain't have no write-ups. I never got rolled up or never got in no trouble. I always distanced myself from trouble. I just want to go home and take care of my family and my kids. My dad and my mom, they're sick. They need my help. I just asked for a second chance.
Thank you so much.
Yes, sir.
Today, Mr. Prater will be handling your case, but we're going to hear from the victim. Are you with us? Okay, you may go ahead. Would you state your name?
Yes,
Okay, you may proceed.
yes. To me, it's very shocking that he is trying to get parole or probation or whatever he's trying to get because he did 2 of my children. Second of all, we made an agreement that he would do all the time. So, and then he wouldn't have to register as a sex offender. So that was the deal. So he even going against the deal that we made. My daughter, so we can have an understanding. My daughter was a baby when I met him. My baby was 6 months. It was my daughter since she was a baby. My daughter told me this was going on as long as she can remember, and I asked her why she didn't tell me. And she told me she didn't know what it was. So I'm just giving you the mental state of this man. My second daughter that he molested, with the first daughter too, he even wanted my daughter to call him father, call him daddy. That's how sick he is. The time that he has gotten for 2 children, my children are damaged mentally because of this. It would never go away. I used to watch Snap on TV, and I used to try to protect my kids thinking I was doing something when I was actually living with a monster myself. I couldn't even think of how or when he was doing these acts, and he's so malicious and sneaky with it that my daughter told me he would do stuff while I'll go walk away to go cook. While I was actually, right in the room with everyone, because I never used to leave my kids like just sitting in a room with him without me. So it was like every time I walk away to go use the bathroom, I don't think he should not be released soon. he is a monster. As many things that you don't even know that he have done. And to people in my family and people that I've known since he been in jail that have came forward to me and told me, he should do all this time. He shouldn't get out. And my daughter wanted to be here, but I forgot that it was 2 days. She wanted to speak. My 16-year-old, my children are really damaged because of him, mentally.
Thank you so much. Thank you. Mr. Prater, did you hear those remarks?
Yes, I did. And I've got a few questions whenever it's appropriate.
Okay, it's appropriate.
All right. Mr. Johnson,
Sir,
are you listening? Okay, I've got a couple of things every now and then because we study so many cases. Some of these things just don't make any sense. And it's really egregious to me to read how the criminal justice system has failed the public on this particular case. You pled, let me ask you this, and of course, you know, I've been doing this a long time, and I don't ask questions I don't know the answer to.
yes, sir.
Did you admitted to cruelty to a juvenile, correct?
I copped out to it. I didn't have a lawyer. I didn't have the money for a lawyer. They went to court. I went to court like numerous of times. They said they was gonna throw the charge out, but I didn't have money for a lawyer. My public defender said it was a good plea to take, so I ended up taking it because I didn't have money for the lawyer. But he said regardless of the fact, I was still gonna lose the case because it's he say and she say. You know,
Did you commit any offense?
no, sir.
You didn't do anything wrong.
No, sir, at all.
Did you tell the judge that when you took your plea?
Yes, sir. Yes, sir. But I was listening to my public defender, so, and I knew I was gonna lose the case unless I have a real lawyer. Me and this woman been together like on and off like 10 years. So I didn't put a lot of trauma in her life. So it's calm. I done wrecked vehicles. We had domestic abuse and stuff like that. So she just really out to get me. But I'm not, I don't know what to say. It's crazy.
Hey, well, let me say something then. You were originally charged with sexual battery of a juvenile, 2 counts.
Yes, ma'am. But they have
Indecent behavior with a juvenile, 2 counts, and aggravated rape. That's what you were originally charged with.
Yes, sir, but they ain't have no evidence at all whatsoever.
Well, that's not exactly accurate. Remember, I told you I usually know more than I may seem like, but they did have evidence. Evidently, because you chose to take a plea that's to something that's not even a sex crime. Do you have to register when you get out?
No, sir.
So even though you were arrested for having sex with 2 kids at 7, 8 years old, then you don't even have to register. So you're going to be moving in next door to somebody and you don't even have to register. That's what I mentioned about the failure of the criminal justice system. And you're going to go home and you've got kids of your own, right?
Yes, sir. Yes, sir.
Have you taken any sexual abuse courses since you've been arrested?
Yes, sir.
Name them.
Living in balance.
Well, that's not, that may have a component to it, but that's not a sexual abuse class, not geared specifically for somebody with the charges. And I understand you're not saying you committed these charges, but you're saying you committed some felonies because you pled guilty to it. So it's just really confusing in your situation.
Yes,
Another sad thing about it to me is you're going to be getting out in February of 26, no matter what we decide. Is that not correct?
I just took another class, so it's December the 28th. Yes, sir.
So you'll be getting out December of 25 next year.
Yes, sir.
Okay, so you're going to get out next year. You don't have to register. In your eyes, you did nothing wrong. And in the court's eyes, you didn't commit a sex crime, so you don't have to register. So I'm just confused. I'm just confused, I guess. You got something else to say?
Yes, sir. While I've been incarcerated, I have asked God to forgive me for the things that I did to her. And, and I just ask for forgiveness. I just want them to know that I still care about them and their feelings.
Okay, let me just make sure I don't, this couldn't get any more boogered up than what it already is. Oh, that's all I got, Mr. Chairman. I'm frustrated.
Ms. Stapleton, do you have any questions?
I sure do. I
Right.
want to ask you about 2016. I see here in 2016 in Tangipahoa, there was other charges brought against you. Domestic abuse battery of a pregnant victim, domestic abuse battery by strangulation, resisting an officer by flight, cruelty to juveniles. So the domestic abuse battery in 2016 of a pregnant woman, who was that woman?
That's my baby mama.
Baby mom.
Yes,
So that's
ma'am.
not Miss Harvey?
No, ma'am. That's what it's all about. I was cheating and I made kids on them and stuff like that.
So you were with Miss Harvey during that time?
Yes, ma'am.
And so then you had another lady,
Yes, ma'am.
okay? Part of that also was a home invasion. What was that about?
It was a big misunderstanding.
I guarantee you. So let me ask you this, let me tell you what a perfect storm is in Louisiana for a homicide. The perfect storm is a domestic abuse battery of a pregnant victim. And then when you add strangulation, the number one cause of death for pregnant women is domestic abuse battery. And then the number one cause of death just by domestic abuse battery is strangulation.
Yes, ma'am.
So what in the heck happened that you did that to this woman? And another thing, before you finish, I want to ask you this one. Cruelty to juveniles. Now, we're seeing here where we've got actually aggravated rape of little girls, and it was pled down to cruelty to juveniles. What did you do to those juveniles?
I was really mean to them. I did not sex with them no kind of way. No kind of way.
You just beat them up?
No. I just was mean to them. I used to kick them out the room. I used to do stuff like that. I used to not let them go outside and play and stuff like that. The mom twisted everything up. But, that's how it be. Females, that's how it be.
Yeah, because you got in 2018, you got a domestic abuse battery against you with children present. Is that Miss Harvey?
That's the same female. She pressed charges on me the whole time. She controlled him. She pressed charges on me the whole time we was together.
Miss Harvey was controlling, or this other lady, the baby mama?
No, Miss Hart.
All right. So, but the other lady was the one you beat up, and she was pregnant and she was strangulated. And so how did Miss Harvey have anything to do with that?
No, that's my baby mom. Like,
Right. So she pressed charge. So we got two women that you've done this to.
No, just one. She put.
Okay, never mind. Never mind.
It's two different situations, yeah. It's two different.
Yeah, I'm seeing that. And two different situations of violence too. So I agree with Mr. Prater. And I agree with Miss Harvey, who called in on behalf of her children. Their lives are forever altered. And you, sir, are a child predator. And you are a danger to society when you do get out, because nobody's going to see you coming again. I don't have any more questions.
Okay, thank you, Ms. Stapleton. Mr. Johnson, I heard you say earlier that you apologized to the mother and you didn't say anything about the kids.
I
Yeah.
apologize to the mother and the kids, the family.
Okay, but you just said the mother in your first statement. That's what kind of caught my eye. And when I was reading through this case, I see where the children were interviewed. And I really don't like going through that because it really, kids, kind of screws them up. But they were saying the things that was happening, and you think the mother encouraged them to say those things?
That mother, she weak. I'm not playing the victim, but she's something.
I see. I have no questions, no more questions. Is the panel ready to vote?
Yes, sir.
Yes, sir.
Mr. Prater?
Deny, for a number of reasons. As I went over, he is not admitting to, you don't get an obscenity charge and plead guilty to an obscenity charge because you won't let the kids go out to play. And so he's not admitting to even what he pled guilty to. And so I have a problem with that. He's going to be getting out next year anyway. And so I don't think he served enough time for the offense that he committed. And I'll leave it at that.
Ms. Stapleton?
I agree with what Mr. Prater just said. He has not served enough time for the offense that he committed. Also, he has an extremely violent history toward women and children based upon his extensive criminal history of violence, those two things.
Thank you so much. My vote is to deny also. Mr. Johnson, your parole has been denied, and this concludes our business with you today.
You know, typically I would have blown a gasket. I would just be going nuts. I'd be doing just outrage. But in this case, it I'm just like dumbfounded. And maybe it was validating just to hear the sheriff, how shocked he was at how the system completely failed. And it's like, wow, you know, there are others in charge that see that this is just absolutely insane, that they are releasing a dangerous man, a sex offender, back into the world, a true danger. He doesn't have to register. Who signs these deals? Who makes these deals? This guy is a career felon, a monster, a danger. He has a track record. You hear them talking about it. Even Mr. Tillis got in a few words edgewise. You know, some hearings, you can go through a whole hearing and you don't get anything. There was mic drop after mic drop after mic drop after mic drop from the mother of the victims. I mean, she came out there and just stating all these facts, and it's like, oh my God. You know that home invasion? He said, "Oh, misunderstanding." Richard found the article on that. He attacked the house with his 18-month-old son and wife with the machete. That was the home invasion. That was the misunderstanding. They're sending him back home to his kids. What? You know, this is the kind of case where the DA needs to be looked into, fired immediately. Whoever this DA was, it should be criminal. How do you sign a plea deal where you don't even need to register? And because he doesn't even have sex offenses, he gets good time. See, those sex offenders don't get good time. He gets good time. He's getting out because of these programs he's taken. He's not even, he's getting out next year. He was just locked up for this. It's insane. I mean, the idea that someone is put in charge, their job as a district attorney is to keep their community safe. And then they go and make a plea deal that is so, it's so shocking that you couldn't believe it. The sheriff is just dumbfounded. He's like, what is happening here? This is a miscarriage of justice. The legal system has failed everybody. And again, this is why we do this, because this will get eyeballs. People will see it and they'll say, oh my God. And to think that that person is still prosecuting cases, if you want to call it that, it's not prosecuting, it's helping dangerous criminals. It's the opposite of what his job is supposed to be. I mean, this is something I hope that a journalist picks this up. This needs action. This DA needs to make a statement about this. He needs to be held accountable, or she. I don't know. Who knows who it is. I'm just dumbfounded. Like, it doesn't need me to go. This case speaks for itself. The parole board spoke for all of us. Everything I'm saying is redundant. Thank you, Richard, for the info. This is his 2018 attack. A 22-year-old man pled not guilty Tuesday for assault with a dangerous weapon, endangerment of a child, and other charges. This is what Miss Stapleton was saying. Man, I love her. I love Sheriff and Miss Stapleton are great. Used a machete to hack a door between him and his housemate and the man's family. He allegedly returned from a party to the home where he is currently living, and was angered that pieces of his bedroom door that had previously been damaged had fallen off when his housemate entered the room to get something, according to the police report, which separately listed the address. Okay. The housemate retreated to his own bedroom where his wife and their 18-month-old son took refuge while Johnson attacked the door with the machete. Just a misunderstanding, remember? And he sits there all like polite with his and it's like, police responded to the house of Millston Road after a 911 call came in at 5 a.m. Johnson pled not guilty to 2 counts of assault with a dangerous weapon and reckless endangerment of a child. And by the way, they dropped these charges. They dropped them because they said that they couldn't get anyone to testify. The victims weren't cooperating, and we have seen DAs that they'll still prosecute even if the victims aren't testifying. They can still do that. But they're, you can tell this is a weak DA. This is a lazy DA. Can you imagine living under this DA's? What's he busy doing? Are they looking for possession with intent to distribute marijuana? Are they going after, is it white collar crimes they're going after? I'm curious what they deem important. What are they spending their time on? Is it a lot of parking tickets? Holy cow, he'll be out. He'll be out next year, and with that, not even needing to register. Just think about that. There we go.
Yeah. So that's a very trusted individual. And most little girls, if a daddy puts their arms around them, it's because he just adores them. And from what I could read, she had to trade you quid pro quo. If she did something, even in the way of the pictures, that's how she would get something from you. Is that the way it worked?
We are about to watch the parole hearing of a monster, of a man who did this to his stepdaughter. Now, this case, we actually have the entire appeal because he went to trial. He was found guilty by a jury, and yet a judge felt, even with all of that, that he would only get 15 years, if you can believe it. We're going to hear from the survivor today, and then I'll unpack it with the details of the appeal at the end.
Would you give your name and DOC number, please?
My name is Roger Allen. My DOC number is 578158.
You're a first-class offender. The offense is aggravated incest molestation of a juvenile. Your sentencing was December 10th, 2010. The sentence was 15 years with the Department of Corrections, each count concurrently. Your parole date is 6/14/23. Your good time date is not eligible. Your full term is 9/13/25. Do you have a questionnaire in front of you?
No, sir.
I'm sorry. Forget that. Okay, I'll be handling your case today. And do you have a statement that you'd like to make before we start?
Yes, sir. In 2007, I was addicted to hydrocodone, alcohol, and I smoked the occasional joint. It's not an excuse, it's just a fact. I was, even though my inhibitions were down, I still had control of my faculties. I knew right from wrong. What I did was repugnant and reprehensible. It 5 pictures destroyed everything. It destroyed my family, it destroyed my marriage, it destroyed my relationships, and it destroyed any trust that I had built. It's taken a long time for me to learn to forgive myself, and I can only hope and pray that somehow, some way, she can learn to forgive me as well.
Thank you. We have an opposition this morning. Ms. Nomi DeVille, is she with us?
Yes, Your Honor.
You can speak, please.
Do I speak to you, the court, or do I speak to Roger?
All of us are listening.
Okay. Although I appreciate, Roger not admitting, but apologizing, I guess, or maybe some type of remorse for what he did to me. I'm sorry.
Take your time.
I'm sorry. I didn't think that. I apologize. I didn't think that it was gonna affect me so many years later. My relationship with my entire family is ruined still. Even though Roger was convicted and the evidence was presented, somehow he was able to convince my entire family that I was a master manipulator at 15, 16 years old. When really all I needed was someone to protect me, which my mother and Roger failed to do. Roger gained my trust, and I eventually looked at him as my father because my own father was fighting his own demons. And as a child, I was desperate for a father and a family. And all I got in return was sexual abuse. And I felt he took my privacy away from me. He took my entire family away from me. I feel severely affected to this day by what he has done to me. He speaks about how he lost everything. It was nothing compared to what you made me lose as a child. And although me attending today and speaking how I feel on this matter, he's still getting out next year no matter what. And I feel like it's just not justified. That's all I want to say. Thank you.
Thank you so much. Thank you. Mr. Rogers, I'm handling your case. I read your case. I went through it very thoroughly. I see that you've taken a lot of classes to better yourself. How long have you been incarcerated?
14 years.
14 years. As you see, it wasn't a good thing, but I'm not here to talk to you about that. I have no questions, and I'm going to let my colleagues, if they have questions that they want to ask. Ms. Stapleton.
Yes, sir, I do. First of all, I want to commend Naomi for your bravery to appear today before the board. That's very difficult for any victim to do. And we could see your pain and we could hear your anguish over the childhood you lost. So you have my deepest, I don't know, I would say sympathy, but that's just not even the right word. Okay, so let me get to Roger. Roger, at the time this happened, am I correct? You were 40 years old and she was 15. Is that correct?
Yes, ma'am. About
And approximately. And she did see you as a father figure. Is that correct?
yes, ma'am.
Yeah. So that's a very trusted individual. And you know, most little girls, if a daddy puts their arms around them, it's because he just adores them. And from what I could read, she had to trade you quid pro quo. If she did something, even in the way of the pictures, that's how she would get something from you. Is that the way it worked? Like if she wanted to go somewhere or get some money or anything like that, she had to pose for pictures or she had to do something.
No, ma'am, it wasn't like that. I really don't even know what was going through my mind or what. I'm sorry.
Well, we know the pictures got taken.
Yes, ma'am.
As a child, she was finally able to get somebody to believe her. And thank goodness for that, because from what I could read, she tried it another time and nobody did believe her, but she finally did. And she was able to give police the information as to where to be able to find them on the internet. So that proved that what she was saying was true. Am I correct when I say that?
Yes, ma'am.
Yes. And so that is how they came up with the fact that you got the charges. Your original charge was aggravated incest, sexual battery, and pornography of a juvenile. Is that correct?
I don't
Original
know.
charge. You don't know. I got you. But then it was pled down to aggravated incest and molestation of a juvenile, of which you got 15 years for each one of those crimes, but they run concurrent. So actually you're serving just 15 years.
Yes, ma'am.
Okay. Okay, that's all that I have. I think that right now I read that there is extreme opposition from the district attorney and the sheriff for any early release, but even an early release, you're going to get out next year anyway. But that is what they had to say about the situation. All right, I'll turn it over to my colleague, board member, Mr. Prater, if he has anything he'd like to say.
No questions.
Okay,
Okay,
is the board prepared to vote?
I am.
Since I handle your case, Mr. Rogers, I'm going to vote first. I mean, I think I read your case several times, and I congratulate you on the classes and stuff that you're taking, and which I think is good. I see that you have remorse, and that's good. And you're trying to reform yourself. My vote today is to deny. Ms. Stapleton.
My vote today is to deny also. I did see the classes and maybe it just didn't show up, but I didn't see that you took any sex offender class. Am I correct or wrong about that? Did you take anything, a sex offender class?
I've never been in a place that offered it.
Ah, That does happen. Okay, I forgot to ask that question. So yes, my vote today is to deny.
Mr. Prater?
My vote's to deny also, and with the recommendation, if at all possible, that DLC find a place that he can go to for a long-term sexual abuse classes before his release. His release is going to be next year anyway, so let's try to get that done if at all possible for the Department of Corrections. Thank you. Deny.
Thank you. Mr. Rogers, your case has been denied. Your parole has been denied, and I wish you luck. This concludes this case. We're signing off. Thank you. At 9:51.
Can you even imagine his opening remarks? What he says is, it destroyed my family, it destroyed my relationships, it destroyed the trust I had built. I pray she can forgive me. Are you kidding me? Mr. Tillis actually says at the end, I see you show remorse. I see you took programs. The guy didn't even take a sex offender program. This, he described his crime as repugnant. This roach is repugnant. The judge that sentenced him is repugnant. To run the sentences concurrent, he should be serving another 16 years, not 1 year, as Richard noted. And we'll go through the appeal. Can you imagine? He went to trial. This wasn't a plea deal. He went to trial. He put the state through the cost of prosecuting him. He put his victim on the stand. And when a jury finds him guilty, the judge thinks that 15 years is enough? Why? Let me sit down across from that judge and say, really, Judge, sir, why? To what benefit? For what reason? He drags the entire, he makes everybody go to trial because he denies his guilt. He wants to continue to prove that he is innocent. He's being wrongfully accused. And then when a jury finds him guilty, the judge is lenient with him. Make it make sense. It's like finally a DA says, we're going to go and prosecute. And then it's the judge that just says, I don't care. It's just a child. Who cares? So let's go through it. All right. The defendant was charged with the amended bail of committing from December 2007 to 2008 one count of molestation of a juvenile when the offender has control or supervision, and one count of aggravated incest, count 2. The defendant pled not guilty on both counts. Following a jury trial, he was charged on both counts, and on each count, he was sentenced to serve 15 years of imprisonment. But the judge, in his wisdom, or her wisdom, decided, if you can imagine, to run them concurrently. So it's just 15 years. First of all, the legislation allows for more than that for these crimes. You can get, I believe, up to, it depends on the they call it crime against nature, incest charge, up to 50 years. In some cases, the maximum is 20 years. So I'm not sure which one he's fell under, but 15 is the minimum that legislation says you have to get. So the judge went out of his way to give the absolute minimum sentence. Why? No one with any common sense no one can give an answer that would justify that. Why, Judge? Why? Seriously, why? And then the next thing I would love to know is why the DA felt that they can only bring these 2 charges. When you go through the appeal, you're going to see that they could have charged him with manufacturing of CP. They could have charged him with distribution of it. They could have charged him with he does. What we're going to go through this appeal is insane. I mean, it should have been full on sexual assault. I don't know why they didn't bring those charges. So the fact of the case, after the victim, the survivor, testified that her stepfather, she testified that she had left her mother's house and then moved in with her biological father for a few months because the defendant was being inappropriate with her. She stated that when she was 13 years old and in her bed with a headache, the defendant came to rub her back, but started to rub her on top of her shirt and then under her shirt. And this is just the beginning. She kept telling him to stop, but he would move her hands, on her. The victim indicated that a few days, a week, the defendant would, I'm not going to read this out loud, but basically full-on assault. The victim testified that after she moved back in with her mother and the defendant would grab her. According to the victim, the defendant also showed her pictures of naked girls and women. She alleged that he showed her porn on his computer. She also stated that the defendant wanted her to wear lingerie-type outfits and cut a long black tank top just below her breast and then cut a slit in the front of her shirt. Additionally, she testified that the defendant kept telling me that he wanted to lay like behind me naked and telling me that he wanted to have sex with me and he wanted to do the other acts. She stated that when she was 15, the defendant continuously asked her for naked pictures, and he took some pictures of her when she was naked. She indicated that the defendant put the naked pictures on his computer. She identified State Exhibit 3, which included numerous photographs of a naked or partially clothed young girl, as photographs of her. I mean, this is why didn't they not charge him for creation of producing child CP? Why? Why didn't the DA bring that charge? I don't understand. She stated that she copied the photographs from the email the defendant had sent out on his computer and then distribution of it. This is insane. SB also testified at the trial that now here's someone else they're bringing in. This is another victim. Because the initial victim goes by the initials of ND, and now this is SB. So they bring another victim. She's older, but she indicates that the defendant was 4 years and 3 months older than her. She stated that she had known the defendant all her life. Her mother and the defendant's mother were best friends, and she lived in the same house with the defendant for 3 or 4 years after her mother moved from the divorce. She testified when she was 8 years old, the defendant, so when she was 8 and the defendant was 12 and a half, the defendant would wake her up in the middle of the night, take her into his mother's room and tell her to sit on his lap naked from the waist down and try to penetrate her. Additionally stated that the defendant would take her into his room to make her give him sex. And so this is part of the argument saying that this wasn't relevant. They couldn't bring this up. But and it is quite interesting that there's, but as you can see, this guy has been doing this stuff for forever. SB further testified that when she was 9 years old, the defendant took her into her mother's bedroom and penetrated her to the fullest. While sitting on his lap, she started to bleed and she got up. The defendant said, "I popped your cherry." She also stated that when she was 9 years old, the defendant took her into the garage, made her undress from the waist down, and made her sit on the lap of one of his friends. The defendant told her to be a good girl. The defendant knew SB was, and she had sex with his friend. SB testified that on another occasion, the defendant and his friend Scott held her down in the bed while Scott's older brother, he conceded he received a bad conduct discharge from the Navy for burglary. What a shock. He also conceded that he had made a video of his wife having sex and put it on his computer. He also has nude photos of his wife on his computer. However, he denied grabbing the victim. He also denied taking the pictures of her. So it is interesting that they were able to bring that up. I get that's part of his appeal, but other crimes and assignment of error. Number one, the defendant argues the trial court erred in allowing the state to admit evidence of other wrong acts concerning the alleged incident that occurred over 20 years earlier when the defendant was a child, because the defendant unfairly prejudice his case. I mean, I do hear that as a legal argument, how that could be relevant. I mean, he was also a child. The presumption of innocence and improperly supported the victim's credibility, relevant evidence having any tendency to make the existence of any facts the consequence. Okay. I mean, it's just like another, it's just, I don't really know why the DA would bring that, but I guess I'm getting distracted by this appeal. The bottom line, facts of this case is that he was found guilty. The judge could have sentenced him much more. And then even when he gives him these light sentences, he runs them concurrent. Are you kidding me? It's insane. It's insane. It's madness. And it was nice to see, you know, Miss Stapleton, the victim's advocate, to say such kind words and to be so supportive. It makes a big difference. But you probably wouldn't believe this stuff if you didn't see it. And, you know, you have the monster on one hand, but then you have the system. You have a judge that really, you can clearly see, does not care about protecting the community, about protecting children, about, you know, the most simple things that I think so many of us would just see this and say, wait a minute, why are you giving him a minimum sentence? This wasn't a plea deal. He went to trial. He cost he made the state prosecute him. Why reward him with a light sentence? Anyways.
Okay, and you were what, approximately 38 years old at the time?
I think I was 35.
Oh, 35, okay, and she was 10. Okay, and how many times did it happen?
Twice.
Twice?
Yes, ma'am.
Mm-hmm.
You know, before I even saw the hearing, I knew that he was locked up for these kind of offenses. Unfortunately, we see that many inmates try to hijack the crucifix and put it around their neck for these parole hearings, thinking that they're going to fool us. And yet they don't know that it's actually a big symbol saying, look at what I did. Look what's in my jacket.
Second offense was forcible, 2 counts, introducing or contraband in a municipal or parish prison or jail. Sentencing date 9/5/2027. Sentence to 20 years of labor, each count to run concurrent. 2 years for labor run consecutively. Parole date is 8/8/2024. Good time date is 10/20/2034. Full term date is 2/8/2036. Would you like to make a statement?
Yes, sir. I would like to start off by saying that I apologize for my foolish action for causing pain and hurt to so many people that love me. And they were stupid for even putting myself in a situation like that. And I'm kind of glad that I'm in the position I'm in right now for better correction and conviction, and would like to share that, to be able to share that with others whenever I do get out, so they won't make the same decisions that I made, you know. And I would like to learn. I learned how to discipline myself and to be focused, more focused and positive, to establish a more productive life and regain my sanity. And I would like to be able to share that with others on the outside for better productive life and correction.
Thank you. Would the staff like to read what they have?
Yes, sir. We've had Mr. Jones here for a while. He completed the 9th grade, but he's currently enrolled in GED here at CPCF. Mr. Jones is also currently enrolled in Thinking for a Change, and he is in our faith-based Christian dorm where he participates in Recovery Through Christ. Malachi Dads, and other programs. He is also doing a distant learning Bible course that he's been doing off and on since I think 2021. The staff here have had no problems with Mr. Jones. The GED lady instructor wrote a letter on his behalf. I don't know if you want me to read the letter she wrote.
Yes, please.
She said, "Dear Parole Board, I'm writing to express my unyielding support for Bourne Jones, who is up for parole review. My student, Bourne Jones, has exemplified how a student should conduct himself. He has been a pleasure to instruct, studious, eager to learn, and has worked very hard to meet all of his class obligations. During his incarceration, he has made commendable efforts to rectify his past wrongs, have engaged in multiple programs aimed at self-improvement and skills acquisitions, and she sincerely urges the board to consider this letter of support during his upcoming hearing. Thank you for your time and consideration, Ms. Delta Grove."
Thank you so much. Thank you. We appreciate it.
Did
We
y'all get a copy of all his certificates?
Yes, we have copies of it. Yes.
And then our security staff also said that they have had no discipline reports on him. He works as our hall man. As needed, gives them no problems. He's not had any write-ups, and they had nothing but good things to say about his behavior on compound.
Thank you so much. We have someone too here on your behalf, and that is Ms. Freeman. Frida Edmond, your aunt.
Yes, sir.
She's going to speak, and then Vicki Holmes is here on your behalf, and Miss Mildred Holmes Jones, your aunt. She's here too, but Frida Edmond is going to speak. Is she ready? Miss Edmond?
Yeah, good evening. Good evening. I'm Frida Edmond. Thank you all for taking the opportunity to hear me. I'm Vaughn Jones's aunt, oldest aunt. And I feel and believe that he has learned his lesson and he's taken the right path into correcting his life. And I feel as though given a second chance, he would be a more productive citizen. We have established everything for him to come home. And even though I don't live in Ville Platte, I live in Shreveport, and but I go home a lot. And my nephews and nieces and all them, they do depend on me, and I'm there for them, as well as my other siblings. So I think giving him that second chance would not only be beneficial to him, but others he may encounter to help them to change their lives if they're on the wrong path. But I think he'll be a great mentor in the community, letting everyone see how he have changed. And I see just by looking at him, he has changed. His demeanor is different, you know? So I would appreciate it if you all would consider granting him this parole. And I promise I'll do everything in my ability to ensure that he does not go back. And whatever I can do financially, emotionally, physically for him, I am willing to do that.
Thank you so much. Thank you.
Thank you.
Mr. Jones, Ms. Stapleton is handling your case today, and I'm going to turn it over to her.
Okay, so there wasn't anybody else who wanted to speak? They're just present?
So it was just one.
Okay, that's fine. Okay, yes, sir. Mr. Jones, I'd like for you to tell me how you got that charge of aggravated 2 counts, because that's what your actual charge was. How did that happen?
It all started behind a message in the phone.
With the 10-year-old?
Yes. Then,
You were living there now, right?
yes, ma'am.
And so
I
you're
was living there at the time, yes, ma'am.
right. And so you're texting this 10-year-old?
No, it started behind a text in the phone. And the phone that she had, it was for somebody else. And the person that they gave it back to went through it, and it had a text in there that said that that my mom and dad is fussing, and that she won't be able to have sex with her dad tonight. That's what the text said.
Mm-hmm.
And the phone, and it all and stuff just start transpiring according to that.
Right. And who found that, Tom, by the way? Was it an aunt? Somebody like that?
No, the mother gave it to her ex-boyfriend.
Okay. And so that's when that text was discovered.
Yes, ma'am.
And they decided to check with the daughter to see what was going on.
Yes, ma'am.
Okay. And did the daughter tell him at first what was going on? She was only 10 years old.
Yeah, at first she denied the allegation because it was me, her, and her grandfather sitting down talking, and she denied it at first, but afterwards, when they took her to the hospital and found out that she was been tampered with, and that's when and everything else just escalated from there.
Yeah, that's what I read, that the child was questioned in front of you as to whether or not it had happened.
Yes, ma'am.
That's traumatizing right there. So then they go to the hospital and they examine the child.
Yes, ma'am.
And they find out, in fact, there had been sexual intercourse. Am I correct?
Yes, ma'am.
So where do you get involved in that?
Well, I was there. I was living there at the time.
And so you did it or didn't do it?
I mean, I'm guilty of the charge.
Right. That's what I'm trying to get to. So you're the one that had sexual intercourse with a 10-year-old, right?
Yes, ma'am.
Okay. And you were what, approximately 38 years old at the time?
I think I was 35.
Oh, 35. Okay. And she was 10. Okay. And how many times did it happen?
Twice.
Twice?
Yes, ma'am.
Mm-hmm. Okay, let's see what else. Yeah. All right. And so then that charge, which was actually aggravated rape, it got pled down to forcible rape. Am I correct?
Yes, ma'am.
And both of those were 2 counts.
Yes, ma'am.
Now, had you gotten aggravated rape, I'm thinking by today's charges, an aggravated rape would be a life sentence.
Yes, ma'am.
Yeah. And so you would have had 2 life sentences had you gotten what you actually did. So now you've been pled down to 20 years and it's for 2 counts and they're going to run concurrent. Am I correct?
Ma'am.
Is there anything else you'd like to say to me about all this? I mean, not just me, everybody, anybody.
Yes, ma'am. I'm true to apologize for my actions and my wrongs, and I admit to my wrongs. And I've been sitting down to have time to think about everything that I have done, and I'm truly apologize for it, and I'm sorry that it ever happened and it ever crossed in my mind to even think about doing something so foolish as that. And I'm sorry for hurting those that I have done it to, and the family of those that I have done it to. And hopefully, deeply they accept my apology and forgive me, so I could strengthen myself to strengthen others.
Well, let me tell you something. The word you keep using twice, that it was a foolish action, you used that word, and now you just again said foolish. What you did was not foolish, it was heinous and it was cruel. And we just had a young lady, that appeared that something like this happened to her. And I've heard other young victims say the same thing. They just simply don't recover from it because you stole that baby's innocence. I want you to know that it is not a foolish action. It is a lifelong action to that victim. You robbed from her something she will never get back. I want you to know that you have strong opposition from the DA's office. And the statement is the victim was only 10 years old. And you also have strong opposition from the sheriff's office. That is all I have to say. So it goes to whoever would like to speak next.
Mr. Prater, you have any questions?
No question.
I have no questions also. Is the board ready to vote?
Yes,
Ms. Stapleton?
I vote to deny because you need more time there. I didn't notice that you had any sex offender classes. You do have a lot of classes, but I didn't notice sex offender classes. So if I'm wrong about that, I hope that you will get some sex offender classes. And I think you need to spend more time so that you can accomplish at least those goals, and you just haven't served enough time as a heinous crime.
Mr. Prater?
Nah.
I'm sorry, I didn't hear you.
Just deny, not enough time. Sorry.
Yes. Mr. Jones, my vote is also to deny. I'm glad that you're taking some steps forward and doing some good things there where you are. I think you need to get some more sexual abuse classes, and I hope that you will continue on this good path. This concludes, you've been denied today, and this concludes our business for today. We're going to sign off at 12:42 p.m.
Gosh, I love Miss Stapleton. She comes in with the mic drops, and it's just like her look. She looks like this, like the grandmother next door, just the classic, you know. And then she comes on there with this power. I have to make shorts with her because for YouTube shorts, because man, it just like catches you off guard. It's so powerful. And she really cares. You should check out, we've gone through her bio a few times, but she is the victim's advocate. You know, she replaced Mr. Roche, who most of us love and adore. I know I do. But if we could have picked anyone to replace him, it would be Miss Stapleton. And she's just amazing. She's, and yeah, the DAs, you know, they give him these sentences like he could have gotten two life sentences. They give him a deal, but he's up for parole, you know, pretty quickly. Remember he only took the plea deal in 2017, and they're just two-faced. You know, they write a letter. At least they wrote a letter. They don't show up. But they write a letter. But they're the ones that made the plea deal. It's like, what? I mean, she's 10 years old. 10 years old. Like, how are you not given the life sentences? Well, what? Like, it's just, I can never get over it. You know, thank you, Richard, for sharing the information. There's no appeal. Thank God there was even an article. We don't see this stuff, right? They don't write about these things because it's just children. We know that, but Jones pled guilty to 2 counts of forcible sexual assault for incidents that occurred in early 2014. His plea came a mere couple of hours before a jury was to be selected for Jones' trial. So he was playing, you know, they do this often. They play the games. They're like, you know, well, we're not taking a plea deal. We're going to go to trial. And I guess let's give the DA credit. They were going to take this to trial. They were going through the process. And he thought he would call their bluff, but he realized that no, that's big a trial. So he said, okay, I'll do the plea deal. Jones was originally charged with aggravated sexual assault in this matter. In the bill of indictment of these charges, it stated that Jones, on or between January 1st, 2014 and May 26, 2014, committed offenses of this nature upon a 10-year-old everything. He look at what he did. Look at what he did. Why? Jones, however, pled guilty to 2 counts and received 20-year sentence for each count, but they're running concurrently. Does that sound familiar? Huh. How often do we see that? Or at the same time, Jones also received a charge for introducing, possessing contraband in any municipal parish or jail. For this crime, the man was sentenced to 2 years of hard labor. I like how, 2 years for bringing that into jail, 20 years for doing that to a 10-year-old. The sentence was set to run consecutively with his 20-year sentence, so he gets a total of 22 years. Following the plea, the parish district attorney, Trent Brignac, complimented the efforts of Chris Ledoux, who was prosecuting the assistant district attorney in this matter, and Judge Chuck West, who was the presiding judge in this case. Chris Ledoux worked very tirelessly preparing for this case, and I want to compliment him on the hard work he put in leading up to the trial. I also want to compliment the judge on the preparation he had to do, as well as leading up to his trial, so that he could make well-informed decisions. And that's why we gave him a 20-year deal. I am proud. Psychopaths. They had the evidence. They had everything they needed to put him away for life. Yeah, that's why we do this. And we're going to watch one more hearing. And today's theme has been about how the system has completely failed the public that it's supposed to serve. We're going to watch another case just like that. Now, it's different than the ones we've seen because it's not harm to a child. Instead, it's a woman who just insists to continue to drive under the influence.
Okay, Miss Roby. I noticed that you've been being arrested for DWI for the last 34 years. 34 years ago was the first one I could find. How many times have you been arrested? I don't mean convicted, but how many times have you been arrested for driving while under the influence of alcohol or drugs?
4.
Are you sure that's all?
Not really. I'm not really sure.
Because I find many more than 4. What about in Mississippi?
Yes, I had 2 in Mississippi.
2 in Mississippi, and how many here in Louisiana?
I can't recall.
Did you get a question there?
No,
Yes,
sir.
sir.
No, sir.
I'm sorry. This is a program. Good. Today, your case is being handled. I'm going to read the charges against you. The first offender, the offenses are operating a vehicle while intoxicated. The 3rd time, operating a vehicle while intoxicated. The 4th time. Sentencing was on January 24th, 2023. Sentencing was 5 years without the benefit of parole or supervision of sentence. The second one was 10 years, 2 years without the benefit of probation, parole or suspension of sentence. Your parole date is 10/17/24. Good time date is 6/17/25. Your full term date is 4/16/2032. Today, Mr. Prater will be handling your case. And would you like to make a statement before he starts?
Yes, I would.
Go ahead, proceed.
I wrote a letter for the parole board. I'm saying this to express my sincere remorse for all of my past actions, to prove my personal growth I achieved during my incarceration, and to show my plans for a positive, productive future if granted parole. I understand the gravity of my mistake and the impact on everyone, and am committed to making amends and contributing positively to society. I want to acknowledge the seriousness of my crime and take full responsibility for my actions and the harm they caused and could have caused. My actions wasn't only illegal but morally wrong, and I'm truly sorry for my behavior caused everyone involved and for the potential harm I could have potentially caused. During my time in prison, I made an effort to reflect on my past and to understand my underlying issues that led to my criminal behavior. I participated in the reentry class that was instrumental in helping me develop better coping skills, improve my decision-making skills, and gain a deeper understanding of the impact of my actions. I'm fortunate to have a strong support system in place, as my family has been incredibly supportive during my incarceration. And I am committed to helping me integrate into society. I also established connections with community organizations that offer resources and support for individual transition for prison. These connections will be crucial in my staying on the right path and avoid pitfalls that led to my previous actions. If granted parole, I got a clear path for my future. I secured a job at OCM, where I have been working since entering the work release program, which will provide me with financial stability and a sense of responsibility. They would also help me get into my own apartment, giving me some sense of independence. In conclusion, I want to reiterate my deepest remorse for my actions and my commitment to making amends. I use my time in incarceration to reflect, grow, and to prepare for a better future. And I'm ready to take on the responsibility and challenges of life outside of prison. I'm committed to being a law-abiding, productive member of society, and I respectfully ask the opportunity to prove myself and make a positive impact on the world. Thank you.
Thank you so much. Thank you. Mr. Prater is handling your case today, and he will take it over from here. You ready, Mr. Prater? Mr. Prater?
Yes, sir, I'm ready. Yes, ma'am, Miss Roby. Is that what I should call you? Is Miss Roby?
Yes, sir.
Okay, Miss Roby. I noticed that you've been being arrested for DWI for the last 34 years. 34 years ago was the first one I could find. How many times have you been arrested? I don't mean convicted, but how many times have you been arrested for driving while under the influence of alcohol or drugs?
4.
Are you sure that's all?
Not really. I'm not really sure.
Because I find many more than 4. What about in Mississippi?
Yes, I had 2 in Mississippi.
2 in Mississippi, and how many here in Louisiana?
I can't recall.
Okay. All right. Have you had any substance abuse classes since you've been incarcerated?
No, sir. All I have was a reentry.
Okay, you were sentenced in 23. That was last year, really. You were sentenced in 23 to 5 years and 10 years. And of course, 5 years with the condition you serve 1, and 10 years with the condition you serve 2 without benefit of parole, probation, or suspension of sentence. But you hadn't served really but 18 months. And my question is, without any substance abuse classes, I don't know if they're available there. But I'm having a hard time because we have to, on the parole board, our decision is what's best for the public. The public safety is the number one thing, more than anything else. And it's not safe for the public to put you out there having 34 years of DWIs that you don't even know how many times you've been arrested, and now they're asking us to let you out early. And I'm starting to tell you what my vote's going to be, but I don't mean to. Okay, so I'm ready to vote, sir. I'm through questioning.
Ms. Stapleton, you have any questions?
You're on mute.
Ms. Carroll, you're on mute.
Okay,
Right.
I found the same thing that Mr. Prater did, the long criminal history of substance abuse and domestic violence, which is definitely a public safety hazard. You already have 4 convictions for that. Also, you talked about your family support. So tell me about that. I think that's a problem. I don't know about your family support. I'm reading some opposition. They're kind of worried about you coming home too. So can you say anything about that? Your sister, your mother?
My sister is supporting me.
Do you have 2 sisters?
My mother's in a nursing home.
Do you have 2 sisters?
Yes, I do.
Okay, so one sister maybe is supporting, the other's not?
Yeah, well, the other one, nobody really gets along with.
Oh, okay, maybe
So
she
we
didn't
don't
go.
talk to her.
Oh, okay. All
Yeah.
right. So you got the support of one sister, but not the other, and your mother's in a nursing home.
Yes.
Okay. Look, I don't have any more questions because I see too that if they don't have substance abuse classes there, or if you've just chosen not to take them, I don't know which it is, but if they don't have substance abuse classes, I hope that we can request that you be moved to a place where you can get those classes if you so desire. If you don't, that's another problem. Would you want to go to a substance abuse class?
No, because I want to stay at my job.
Ah, okay. What about AA and NA meetings there? Do they have that?
No.
No. So what's important to you right now is to stay in your job and to be treated for your addictions is not of any concern.
It is.
I just want to make sure about that.
No, it is a concern, but I want to stay at my job
Okay, gotcha.
because I got a secure job.
Okay, I got you. No more questions.
Okay, the supervisor inside, is anyone there want to speak on her behalf?
No, sir, we have no comment.
Okay, thank you so much. Is the panel ready to vote?
Yes, sir, I am.
Yes, sir, I am.
Mr. Prater?
Deny this, deny the request for parole.
Ms. Stapleton?
Deny the request for parole, not enough time served, and also no substance abuse classes.
Okay, my vote is to deny also, and I think you need to get some more substance abuse classes before you get back out on the road. Today, your parole has been denied, and this concludes our business with you today. Thank you so much.
Okay.
Signing off at 11:29.
And there you have it. The system failing everyone again. She's getting out what, next year? So she gets sent to prison after getting her who knows how many DUIs. She doesn't even know. A judge says enough, sends her to prison, but she goes to work release. She's at work release. She doesn't take one program. And this actually is something where programs can help. Unlike sex offenders, they can't rewire a brain, right? Not to like what they like. In this case, you can give someone the tools to hopefully stay sober, but they don't. They lock her up so she can go to work and make money. What? Are you kidding me? This system, Department of Corrections, not Department of Go and Work. It's insane. She's dangerous. How many parole hearings do we have to see a woman or men drinking and driving and killing people? We just covered one in Connecticut on my second channel. If you don't know it, this woman, she was an habitual drunk and she kept getting DUIs. And then she got in her car and she drove into 16 motorcycles. She killed someone. Another guy lost his leg. We see it nonstop. There's a hearing out of Utah that we're going to bring to you soon. A young girl coming from Coachella, driving drunk. She killed a mother and a son in the same car. She just had a parole hearing. Go to Mandu 2. The link's in the description below if you want to see these hearings. But for anyone who has, I don't know, who I guess is not running the system, knows that she's dangerous. But they could help. Maybe. If they give her the tools, she'd be safer getting out. But no. They don't even have AA in there. That is the easiest program to set up. But they don't. Or at least according to her. I don't know if it's true. Pretty sure we've seen plenty of I think she's lying. But, we saw a hearing. I wish I could remember which one it was. A long time ago, I played it when I first started the channel. And it was Mr. O'Shea. And it was a very similar situation, except there was a man who was at work release making good money on work release. And he told Mr. O'Shea that he was not going to leave his job to go to Steve Hoyle. And Mr. O'Shea then laid out the law on this guy. It was amazing. He said, okay, well, when you get paroled, this is what you are going to have to do as part of your parole requirements. And he lists how many times he has to go to AA every week. He lists that he needs an ankle monitor. He listed that he needed to do that would test the alcohol. He made this guy that his parole is going to be the most restrictive that we have ever seen. It was amazing. The guy's face, it almost just like he did not realize who he was messing with. And I don't know why this parole board, do they not realize that they don't have the power to do that? They could have created her parole requirements that she would have had to have followed. And, Richard has in the notes, well, they should have just mandated her to leave work release. They do. My understanding is that the parole board does have that type of power. They could have, I think, ordered her to leave work release, but maybe they can't. I don't know. But they could have done the other things. Require interlock device, require the bracelet, require all that stuff. I mean, what an unlikable person, really, is what she was. And it's interesting, don't judge a book by its cover. I thought she looked, kind of like a very the opposite of what you then got, really. And she talks about, oh yeah, the sister, she actually has a sister that doesn't want her back. Oh no, no one likes her. Yeah, okay. Yeah, says the woman locked up in prison. Says the woman, by the way, and I'll just read you these charges because I don't know if I can share the visual of it, but thank you, Richard, for finding it. Not only does she have all these DWIs, but she also has the DV for hurting a simple battery of the infirm. Okay. Yeah. So just, it's not just, she's just not a good, she's not a good person when you can get a battery of the infirm. And it's actually a long list. She has violation of a protective order here. 2 violations of a protective order. One on 11/13/2021 and one on 1/18/2022. So back to back to back. She has the DUI in 8/24/2020. It's insane. But she'll be getting out because, and then guess what? Do any of us actually think that she's not going to get out and the first thing she's going to do is pick up that bottle? Of course she will. Of course she will. And it's going to be dangerous and a life may be lost. But this is what we do. We cover today just how broken the system is. And these are things that really there's no excuse for it happening. There's no excuse for you know, it's like one thing if there's like, you know, mistakes can happen, but how is it possible that on one day we get all these parole hearings where there are clearly errors by or just complete where someone doesn't have to register, they get that deal, where a judge you know, he goes to trial and he doesn't need to serve the terms consecutively, and 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 it's just one after the other, and then a woman who gets locked up for DUI and doesn't take a single class. And we see these all in the same day. These hearings happen all in the same day. So I mean, this is a clear sign that how badly the system is broken. I don't know who should come in here and try to fix this and how that's done, but hey, we're calling it out for what it is. And the sad part, the scary part about all of this, let's be real, is that out of the people that we just saw who will be free soon, there are going to be people who are hurt from them, whether it's kids, whether the data, the statistics, the odds are simply stacked against us. There are too many getting paroled. People are going to be hurt. And I think it just depends how many and how badly. And that, knowing that that's coming and not being able to do anything to stop it is scary. I was going to leave you with that hearing, but then I pulled up this one that Richard sent, and I thought this was actually the perfect ending. It's another, I think, injustice. The sheriff calls it out, and it's just proof of everything that we've been saying. It's someone who has a 25-year sentence for first count with possession with intent to distribute. So let's jump in.
There's always another side of the story. Tell me what the other side of the story is, because we've handled just today as a parole board, we've handled some sex with juveniles and different things where grown men, 30, 40 years old, have had sex with 10-year-olds and they would get 10, 20 years, that sort of thing. 25 years for first offense distribution or possession of methamphetamine with intent to distribute, that seems, I don't want to second guess the judge or anything, but just in globo across all of Louisiana, that seems pretty significant. Why were you given 25 years?
Good afternoon. We're reconvening. 12:51. My name is Chuck Tillis, chairing today. My colleagues are Ms. Stapleton and Mr. Frazier. Would you state your name and DLC number for the record, please?
Tonya Sandifer, 741-247.
With the staff there, identify themselves.
Yes, Warden Washington, Concordia Parish Women's Facility.
Thank you so much. At remote location of Concordia Parish. Ms. Sanders, I'm going to read the charges against you. And they are
Yes, sir.
offense attempted distribution of Schedule 2 methamphetamine. Distribution of Schedule 2 methamphetamine. Sentence date was December 4th. You were sentenced to 25 years of hard labor. Your parole date is August 29th, 2024. Your good time date is November 29th, 2025. Your full term is February 25, 2043. Is that correct?
Yes, sir.
Okay, thank you so much. I will be handling your case today. And would you like to make a statement? And if someone also at the staff there would like to make a statement on your behalf, they can do so after you make your statement. Your statement first.
I don't really know what to say. I've changed within this time that I've been down, learned a lot of lessons, and regret my actions and plan on making better choices and decisions and all in the future.
Okay, is the staff, is there anyone at the staff would like to say something on your behalf?
Yes, I just want you to know that since I've been here, Tonya has been a model inmate. She has been my head cook in the kitchen, and now she is working at the dog pound, our paws. in the parish, and I think she has changed. She's learned lessons. She deserves a second chance.
Thank you so much, Ward. Thank you. I've been assigned your case. And I'd like to ask a question. I'm assuming you had a drug problem.
Yes, sir.
You have. How far did you go in school? What was your level of education?
High school diploma.
You got it, you received it? Are you still
Yes.
working?
Yes, sir.
You are?
No, sir. I received my high school diploma.
And what about the classes and courses that you've taken there? Have you taken some there?
Yes, sir. I've completed all the classes that they offer.
Are there any more that you'd like to take?
Anything that would keep a positive, anything to help me be positive. I don't have a drug problem anymore, but anything that would help me in the future, I'm all for.
I see. Sometimes you do take all the classes that they have, but sometimes you can request to go somewhere else to get some other classes that will better you. So you were distributing drugs, you were selling drugs also?
Actually, that was the very first time that I did, and the last time.
First time that does. I see. I'm going to ask my colleagues if they have any questions. Ms. Stapleton, do you have any questions?
I might. I'm gonna let Mr. Prater go first. He's pretty good on these kind of questions.
Mr. Prater?
Okay, I noticed that the sentencing judge mentioned that you've been found, you've been charged or found guilty or violated some kind of rule at the jail where introducing contraband or something. Tell me about that.
That was I had a watch, a smart watch, and I wore it into it wasn't connected to a phone. I wore it into the jail, but the charges were rejected.
So it wasn't drugs.
No, sir.
Contraband wasn't drugs.
No, sir.
Okay, what kind of plan do you have to stay away from drugs? I noticed you said you don't have a drug problem anymore, and it's my understanding that once you have a addiction problem, you always have one, and it may have just been the way you said it, but what do you plan to do when you get out to stay on the straight and narrow?
Once you're an addict, it was said wrong. Once you're an addict, you are always a recovering addict, and I will be in recovery for the remainder of my life. However, I do have a strong support system with the ladies at Paul's that I've met through working for the shelter. Also, I have a church that I'm going to join as soon as I am released. Also, I have 2 jobs lined up that I'm going to be working. I'm going to stay busy, and I plan on joining NA or, seeking self-help programs.
There's always another side of the story. Tell me what the other side of the story is, because we've handled just today as a parole board, we've handled some sex with juveniles and different things where grown men, 30, 40 years old, have had sex with 10-year-olds and they would get 10, 20 years, that sort of thing. 25 years for first offense distribution or possession of methamphetamine with intent to distribute, that seems, I don't want to second guess the judge or anything, but just in globo across all of Louisiana, that seems pretty significant. Why were you given 25 years?
Whenever they offer, I had never been in trouble prior to this. So whenever I was offered an offer, I didn't know. I was guided to refuse it, that the plea would go down. So it went to trial. And whenever it went to trial, that's when I got the 25.
And how many years have you been in jail since the time you were arrested?
How many years? Approximately 7.
So you served 7 years of a 25-year sentence for possession of meth with intent to distribute.
Yes, sir.
Okay. Okay, that's all I got.
Stapleton?
No, Mr. Prater covered everything I was thinking.
I was looking too, as I read the report, that, your good time is November 29th, 2025, about another year. I heard your statement about the plan you have if released. So, I have no more questions either, and I was puzzled. I'm glad Mr. Prater brought that out. 25 years and you've only done about 7. Is the panel ready to vote?
Yes, sir, I'm ready.
I'm ready.
All right, since I had your case, I'm gonna lead out. My vote today is to deny, simply because you've not served enough time, in my opinion. And I think you need to take some more classes in abuse. And the staff there speaks very highly of you, and that's good. I'm really happy about that, but my vote today is to deny. Ms. Stapleton?
Well, I have to say, I'm really torn. I wish they had like a Steve Hoyle for ladies, because that's a wonderful program for situations like this, but they don't. I'm gonna deny, but you only have 1 more year left. That's right, until your good time date.
Yes, ma'am.
Listen, you have every reason to feel good about yourself and every reason to believe, and you're gonna have to work on it. You're going to go to the NA and AA meetings and stuff. But I do wish you every good fortune in the world.
Thank you.
I'm going to deny today, but continue doing what you're doing, so that when you get out of there, this will be a page you're able to turn in a chapter of life. Okay.
Mr. Prater?
Of course, it doesn't make any difference, but my vote would have been to grant. I think that you've based mainly on what the folks that know you best, and that's the ones that you work with down there. And when the warden will stick their neck out, because they don't normally do that, when the warden sticks their neck out and writes a letter like that, and due to the fact that you served almost all of your sentence already, and you've been a model prisoner and done nothing egregious, I would have voted to. So I'm saying all that to tell you it makes no difference, because it's got to be unanimous. So you're not going to get out today. But I say all that to encourage you. Okay.
Yes, sir.
And so that's all I want to do. I would have voted to grant your parole, but hang in there. You're going to be out in a short while anyway.
Thank you.
Thank you, Mr. Prater. Today, you've been denied your parole, and I wish you well, and this concludes our business for today.
Thank you.
We're signing out at 1:02.
And there you have it. There you have it. The completion of this premiere, an hour and 40 plus minutes long, where we could see it. We saw the sheriff say it himself. We see full grown men. And then you're 25 years. Why? And I love that he said this. Remember, he's been in law enforcement for like 50 years before getting nominated by the governor to be a parole board member, and he retired early as sheriff. He was elected in with 80% of the vote for another term as sheriff, and he retired to take this job. So here is a law enforcement man that is upset about the 25-year sentence, first offense for distribution. We'll go over her appeal, but that's what it is. This is exactly what we've been saying. It's madness. The system, the judge, why did she get the sentence? Because they don't like when you go to trial. Oh, you're going to not take a plea deal? You're going to go to trial? Well, we're going to throw the book at you. But we just saw a case by a man who went to trial for an incest charge. He loses and they don't do anything. Hi, Squishy.
There's 2 to watching. I can play the bigger video.
My 3-year-old, almost 4, walked in.
Like that next to me.
I know. Well, I'll be done in 2 minutes, and then we can play. Okay?
But there's 2.
I know. Give me 2 minutes. Okay?
But 2 can be
I love you. So, and this
can
is.
be a little bit.
He's so cute. Anyways, so you just can't make it up. We saw where this the cockroach goes to trial and loses, and the judge, I'll take it easy on you. I'll give you like 15 years. They can run, at the same time. What's the big deal, But here, 25 years. And man, I love that the sheriff granted, and I think it was a huge mistake for Caroline not to grant. I mean, they said the sweetest, nicest things, but you could have granted. You can reward someone who does really well with parole. She's going to go back and tell her friends, I got parole. There are consequences to that. I mean, reward someone for doing great. Yes, Squishy.
When the timer goes off, you have to go off your thing.
Okay. He set an Alexa timer for me. You hear he calls me Dadadoo. All my kids call me Dadadoo. It's pretty funny. I saw some of you in the change your handles to do at the end, and I love it. I can't. It's so funny. Oh my gosh, you guys crack me up. The best community on YouTube. But this is it. I mean, again, I can't say it enough. It's just madness. They should have granted. They really should have. I wonder if they're going to go to sleep and wish that they had. And I think I saw Richard put in the notes that maybe Tillis only denied because the sheriff at the end mentioned that she had only done 7 years of her sentence. And I thought the same thing. Also, I was like, oh no, when he mentioned that probably led Tillis, because I don't know what Tillis really thinks through these things. And he's just, the more we watch and the least impressed I just, anyways. But how does a judge sleep at night? You're so tough, judge. You're so tough. 25 years. Let's read the appeal too. You're going to see this. And she was probably one of the most likable people that we've seen here, right? I mean, so after a jury trial, the defendant was convicted of distribution of meth, Schedule 2, and attempted distribution of meth. The court imposed consecutive sentences of 25 and 15 years. The defendant appealed. Facts. Tonya was charged with bill of information with distribution. The offenses were committed on May 10, 2016. The LSP were investigating drug crimes and employed police as confidential informant to confect a drug deal between Sandifer and an undercover LSP officer, Sergeant William Moore. On May 10, 2016, Sergeant Moore was working undercover using the alias Luke when he met with her and Misty Holmes at Gum Spring Park. Durbin introduced Sandifer to Luke, and Sandifer entered the passenger side of Luke's vehicle. She sold the undercover officer 1 ounce of meth for $700. The methamphetamine for the purchase was transferred to North Louisiana Crime Lab. Sandifer and Luke exchanged cell phone numbers and texted one another for the next few days. Through text messages, Luke requested another buy in the amount of 4 ounces, and Sandifer checked with the supplier and informed the undercover agent that the price would be $2,450. And I'm being obnoxious because, as we can see, these aren't exactly kingpin dealers, right? We're talking about a few $1,000s in sales. Are you kidding me? 25 years, you bunch of clowns. Alexa just went off. He's going to come in again, I think. He agreed to the price, and the two agreed to meet at Gum Springs May 16, 2016 to complete the transaction due to the risk associated with large drug deals. Large. And 2,500 is a large drug deal. Officer Patrick, in the LSP case, agent in the charge of the operation, decided to intercept the drugs before they were delivered. On May 16, 2016, the alleged supplier was apprehended by the state trooper while Jackson was en route to meet her. Some 4 ounces of substances was recovered from Jackson's vehicle, later tested positive. Sergeant Moore and Sandifer met on May 16, 2016 as scheduled, but she informed him that her supplier had been stopped by a state trooper. She attempted to find a second supplier, but was unable to sell drugs to the agent. So she's such a top dog. She's so big Remember, she's not even the lab, right? So the timer went up. Can you ask Alexa to set the timer for 4 more minutes?
But the timer went off.
Well, I heard that Nightbot has Alexa tied in the basement, so she can't get me.
The timer went off.
I'm almost done.
Okay.
Thank you. So, like, this isn't right. What we just realized here, this isn't even like a real dealer. Like, she was probably dealing little bits. An undercover agent says, "Well, I want $2,500." She's like, "Nice, I'm going to score big." You know, she goes to the supplier. She doesn't even. She's just a middle woman, and they lock her up for 25 years. This is insane. 3 months later, she couldn't even get more. 3 months later, she was arrested on August 10th, 2016. I mean, she's just like side hustling, dealing. She's like a side hustle dealer that, like, really, if this feels like entrapment all over. Someone says, "Hey, give me stuff." Sure. She calls her buddy. The buddy says, "Sure." She's a middleman. Woman. Sorry. The more I read this, like, I was hoping this was the case. You know, the sheriff's like, maybe there's more to it, but there's not. It's actually less severe. It was so insignificant what she did. So insignificant. It couldn't be more insignificant. 3 months later, she's arrested. At trial, she testified that Durbin was living with her and that it was his idea to sell the narcotics. And in fact, Durbin, who introduced her to the undercover officer she knew as Luke, the jury unanimously found her guilty of distribution. 11-1. And that was it. They reviewed the sentencing guideline and concluded that it would impose a sentence of imprisonment because any other sentence would not adequately reflect the seriousness of the offense. Shame on you. Shame on you. What are you talking about? What are you talking about? The court stated that the illegal narcotics are the source of the most evil that occurs in the world. No, it's not. 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 The roaches we just saw, that's evil. Where are your statements for that? These judges are psychopaths. It noted that the destructive effect of drugs have individual lives and families, and drug use tears is the fabric of tears. Bunch of clowns. You know, yeah, meth is bad, but it's not fentanyl, and it's not child molesters. But so yeah, the court also opined to the distribution of narcotics as far as more egregious offense to mere possession, and in this case, the defendant was convicted of distribution, attempted distribution of large. She was please. The court concluded the facts of this case warrant substantial term imprisonment. Accordingly, sentenced 25 years of hard labor for distribution and 15 years of labor for attempted distribution. Clowns. Bunch of clowns. What clowns? Remember, this was also her first offense. She had no felonies. I'm just not doing it. So there you have it. We saw the full circle. I'm done talking. You know, you might not believe it if you didn't see it. It's all here in the record books. And let's go over to the second channel to watch more disturbing hearings out of Utah. If you're not familiar, cover channel, other states on the second channel, Utah, Illinois. We have new Illinois hearings coming out, crazy hearings. Going to bring it to you next week. Iowa, Connecticut, and also another new state that's coming to you soon. Make sure you subscribe there and subscribe here. Help this channel reach 100,000 subscribers so that we can bring more awareness to how insane and broken our system is. With that, I'll let you go. And thank you, Sir Richard.
Y'all have a happy Thursday.